Hello, everyone, and welcome to the program. This is Sunday Politics live on China's television. I'm Sean Okimale in Abuja. Well, before we get into the main discussion of tonight, let's tell you that President Bola Tinubu is done with his business in India, where he attended the G20 leaders meeting, and will now head to the United Arab Emirates, where he will be meeting with the authorities there. The president would meet the UAE authorities during a technical stopover in Abu Dhabi. The president will serve as a follow-up, the meeting will serve as a follow-up discussion to address specific salient issues within the bilateral relationship after conversation held during a recent visit by the UAE ambassador to the president at the State House in Abuja. To our main conversation tonight, everyone. The presidential election petition court has ruled that the election and victory of Bola Tinubu of the All Progressives Congress APC is valid, and turned down the petitions by the petitioners, the APM, the PDP, and the Labour Party. This means that all of the petitioners will have to take their grievances, if they like, upstairs to the Supreme Court if they're not happy with the position of the trial court and the court of first instance. Well, Mr. Peter Obi and Atiku Abubakar say they will appeal the case to the Supreme Court. Tonight, we're taking a closer look at the aftermath of the election, the judgment of the court, and perhaps some very critical lessons that needs to be taken out of the entire process. So I'm talking about the positions of the learned judges, and of course, the lessons for our elections. Don't forget, there will be 3 elections in another 2 months in Imo, Bayelsa, and Kogi State. And there are future elections. And what does this mean for these elections? Let's look at the propriety of what the judges and their stance. It was a unanimous judgment at every point where they ruled on the petitioners' claims. Right. Tonight, we'll be looking at different issues. I will be joined later on the program from a Minister of Aviation and a chieftain of the People's Democratic Party, Mr. Osita Chidoka. But we'll first and foremost have a first conversation with one of Nigeria's senior lawyers, Chief Robert Clark, Senior Advocate of Nigeria, who joins us from Lagos. Chief Clark, it's good to see you. Thank you so much for joining us tonight on the program.
Sure, it is always my pleasure.
Thank you so much.
I can guarantee you that.
Thank you so much, sir. Let's begin the conversation, Chief Clark. You had spoken with me on this program about our elections and the positions of the court over the years, and especially the new dynamics to our elections. But let me first and foremost start this conversation getting your view, your overall assessment of the position, a unanimous decision of the trial court, the Court of Appeal, in the presidential election petition.
Well, my personal view, and I believe my personal view has been enriched with my past experience in the dispensation of justice at the bar. I have every belief, and I seriously believe, that the unanimous judgment of the Court of Appeal is unassailable. It is as fixed as you can fix anything. And I can assure you that if there is an appeal, I doubt whether anything can come out of the appeal.
I mean, that could be extremely categorical and preemptive of what the position of the Supreme Court is. But why would you say that?
Well, let us be clear to ourselves. All the matters based on law that were brought before the tribunal have already been adjudged by the apex court in this country. And therefore, if I were to say my personal reasons, there was no need for the tribunal to have gone through, at least in Atiku's case, where no real point of law was being canvassed. but points of facts. And when in a tribunal, you are bothering the tribunal with points of facts, the law says you must provide the particulars of facts upon which you want the court to, judge the case. As the tribunal rightly said, Atiku's counsels, for one reason or the other, never presented any facts before the court that could warrant the court to look into those facts and be able to say categorically, one way or the other, whether there were merits in those facts or not. Therefore, any reasonable, I'm sorry to use the word lawyer, will never have taken, with those facts available before it, before the tribunal, and asked the tribunal to adjudge on the matter. Secondly, on the question of the Labour Party were pressing their case on the basis that the law is, this is what the law says, this is what the law does not say. Again, almost all the 4 items that the Labour Party presented to the tribunal were decisions that have been held and upheld at the apex court. So what are you asking the tribunal to do? To sit in on an appeal against the judgment of the Supreme Court? Whether Abuja can be granted a special seat as a state in Nigeria has been tabled before the apex court on many occasions, and the apex court has already made profound pronouncements as to the status of Abuja. Now, asking the tribunal to create a special privilege for Abuja in the determination of whether Abuja belongs to one of the states that you must have 25%, or else you die and lose your election if you don't make it. Natural justice, morality, whatever area you now want to turn that statement into, you will find that where morality and the law, as we lawyers will say, come to stand together, priority must be given to what is the position of the law. The law is very clear that Abuja's, even though it is not a state, but the Supreme Court says that we will concede to you that you are a state for other purposes. But nevertheless, we do not advise you to take advantage of the fact that since we have said you can be one of the states, you will now be granted special privileges. That is not the intention of the Supreme Court. Therefore, if the law says to be the president of Nigeria, you must have 25% votes in 2/3 of the states of Nigeria. Then Abuja can be treated as a state out of the 2/3. But to say that since the word "and" had been used, and the English language can be determined in many ways, then you will now say that even if a man wins all the 36 states in Nigeria and has 25%, if he does not have 25% in Abuja, then he is not deemed to have won. Well, I am on air, so I will not use any foul language. A reasoning of that nature needs to be reconsidered. Fortunately, the television that has followed the proceedings in the Court of Appeal has made it so good, because politics in Nigeria has been turned into something else. And I don't blame them. We lawyers used to say in my time that this is the harvest period for lawyers. They believe that if politicians have made their money in very dubious manners, I'm sorry to use the word dubious, but that is the belief of many lawyers. So let us help them spend the money. So we call it the harvest time for lawyers. So lawyers without considering their status at the bar, without considering the fact that they are senior members of the bar, will just take any brief, never thinking whether this state of the law as it is has been determined or not. This is a debate for another date. I will not want to castigate any lawyer. I will not want to impugn on the integrity of any lawyer. But if I were Robert Clark and I was briefed to take the brief of one of the appellants, so-called now, I will refuse it. I will let them know that this area of law, Tinubu has been found not guilty of having been convicted. Tinubu has been found not guilty of having not had the certificate to contest. This Abuja matter has been considered in 3 or 4 other cases.
Yeah,
and I will decline. I will have declined.
Yeah.
Yes, please.
Yeah, and as established by the court previously in Okoyede versus the FCDA, Abia, in the case of the Abia State versus the Attorney General of the Federation, and the position of Section 299 of the Constitution. And I know that the petitioners may not be satisfied with what is happening. If you look at the old gamut of some of these previous cases that I've mentioned, in view of what exactly the law says, the provision of the law in saying 25% into 1/3 of the states of the Federation, plus the FCT, and the FCT that the court has said. A few lawyers had even raised this before the election. The likes of Chief Olisa Agbakoba had raised this issue, that this might come up again, that if you do not win in the FCT, there is a big question mark. If your position is that it gives FCT a special status, if the court had ruled that if you do not win in FCT, you cannot be declared president, how do you think that we can then resolve what has become something like a mischievous reading into the position of the Constitution?
It will not be a mischievous reason. I don't think any court in Nigeria would make such a pronouncement, because the result results in an absurdity, or how do you say? Age is catching up on me. Now, the problem is, how can you say because a man who has majority of plural votes, a man who has won on the remaining 36 states, then cannot be pronounced as president because he did not have 25 of one state? It means you are giving that state a special privilege in the Constitution. And the Supreme Court has consistently said, look, Abuja, you are not a state, but we will concede to you that you are a state in circumstances where we feel you should be regarded as a state. One of the such circumstances is this one. If you want to produce 25%, then it should not mean that by that privilege you supersede all other 36 states. So it's more than absurdity. I believe no reasonable tribunal would have pronounced that.
How do you think going forward that our laws can resolve this? Do you think there needs to be an amendment going forward that there wouldn't be any kind of lacuna or any kind of obscurity or any kind of doubt over the status of wherever you win or where you don't win, especially as it concerns the FCT?
Look, the problem in Nigeria should not be left at the hands of the court. If we continue the way we are going, and we do not look at the processes of our statute in respect of elections, we will continue to be rushing to courts, and we will also continue to be opening our courts to all the biases that we have in this country. Let me be honest with you. The problem in Nigeria today is that the law that creates the Electoral Act has not been very, very nice to Nigerians. Number one, how can you say INEC who is considered as an umpire, you will now say by law, anything INEC does in the course of producing results at an election will be regarded as correct because of the Evidence Act. The Evidence Act says any act or any paper purporting to show any act being done by government agency or by God will be presumed to be correct. So we call it the question of presumption of correctness attached to any document INEC. So if INEC comes to court and says, yeah, I conducted this election, these are the papers I used, and they are all correct, there's a presumption immediately the court will grant it to say, yes, you are correct. Now the onus now shifts to those who are challenging those documents to come and show evidence. And that was what the court was saying. The tribunal said, look, you know the law. You are lawyers of many years standing. So you know that when you come before a court, when pleadings are finished, you must go by your pleadings. If you fail to show evidence, which the law says you must show to topple what INEC says, then why do you have to come to court? Why not go and look for the evidence? Now, Nigerians should learn that the problem, number one problem we have is INEC. Now, if the law is changed that INEC, you go and conduct an election, you come back to us, come and tell us how you conducted it. These are the documents I used. And then you tell the court how you conducted the elections. And the court will see on your own evidence that you have done your job. Not for the court to say, look, my hands are tied. The law says whatever you do, there is a preponderance of correctness attached to it. So we have to look at that aspect and debar INEC that toga of correctness attached in the conduct of the election. Now, again, one very funny thing.
Yeah.
Yes, I'm listening.
Yeah, I'd like to take you to one thing that is very fundamental, since you touched on INEC, and I'd like to get your view on the fact that the Constitution has empowered INEC in the third schedule of the Nigerian Constitution, empowers them that INEC will set up guidelines as it deems fit. It empowers INEC to be able to conduct election in the manner in which it is power and how it deems fit, then in accordance with the electoral law. But then INEC, part of the petitioners claims that INEC promised to transmit results to IREV, a position which the Court of Appeal, I mean, in this presidential petition had thrown out, that they would transmit the election result to IREV. But the court has said, no, legally, that is not totally and absolutely substantiated. How do you then place that based on the constitutional powers that the Constitution has given INEC?
You see, INEC has been enjoined by statute to ensure that in the conduct of its election, it follows not only the statute, but should be able to follow any other rules it brings out. But we should be able to differentiate what constitutes law and what constitutes a discretion. That aspect of the law that you are talking about now only grants INEC a discretion within its rights in conducting an election to do this, do that, and do this. That is, the discretionary aspect of INEC. INEC is telling us now that, yes, I wanted to do it that way, but since it is my discretion, I discovered I had a hitch. I had a hitch, and I could not, because of that hitch, stop doing all other jobs that the Act has asked me to do. Now, by virtue of the doctrine of correctness, If you feel INEC is telling lies, INEC is hiding certain facts, you as the lawyer should now bring out facts to the tribunal to say, look, we don't believe INEC that there was any hitch. Our reasons for not believing are these. You give particulars. It is those particulars that constitute what we lawyers call pleadings. And cases are won and lost on the pleadings before the court. The court says, okay, INEC says I was given a discretion to conduct an election. Unfortunately, I couldn't do it that way because I had a hitch on my machines.
Is that kind of excuse tenable? Is that kind of excuse tenable?
It is. That is the law. If it is a mandatory provision, if it's part of the law that you must transmit in a particular manner, and you did not do it in that particular manner, you have to give reasons. But here, as I told you, that is not the law. The Act does not say the elections must be transmitted electronically. No. It gives INEC the discretion to transmit in whatever way and manner it feels within its own discretion.
But Chief Clerk, Chief Clerk, from the point of law, apologies, sir, from the point of law, the power of INEC has been established that it will conduct an election in a certain way as it deems fit. Now, INEC now says that based on that instrument, this is the manner in which we will do it. This includes transmitting such results through the IREF. Doesn't that in itself satisfactory, and it's an obligation, it brings a burden on the commission to be able to deliver as a commitment that it has given to Nigerians?
You see, the problem with us Nigerians is that we like to hype many things. We allow our political inclinations to affect whatever we do. Look, the same INEC you people are claiming failed to do this, do that. Look at the results in the eastern part of Nigeria. Look at the results from the Delta state. Who has challenged INEC there? In the eastern side, INEC declared that the Labour Party won Obi won almost 95% of the votes. Has anybody challenged that? Nobody. So you claim INEC did so well.
My question is actually not in that respect. My question is as to the transmission of result to the IREF. The petitioners have their problem with INEC and they've taken it to the court. But I mean, on this program, I'm getting your professional view on what you make of the judgment of the letter judges when they said that, well, INEC said that there are glitches. But I'm asking, and I'd like you to enlighten us tonight, that if the Constitution empowers INEC to do a certain duty, and INEC says it promises to do, to carry out such obligation, isn't it a burden for them to deliver? And when they do not deliver, can the INEC be held accountable to such a promise? That's the question, sir.
Okay, let me be honest with you. If I had been briefed to take Peter Obi's brief, and when I looked at all these papers, I would have advised that, look, what you are selling to me to advocate on your behalf in court is not in the law. What is in the law is that INEC, there is no power on INEC to do anything outside the law. What the law gave INEC is a discretion to transmit. And if it does it in one way or the other, or if he had promised to do it in one way and could not do it, as in this case, I would have told them that if I will take the brief, you have to show me that INEC says, oh, I had hitches. Have you got evidence that that statement is not correct? If they said, yes, we have evidence, then I'll ask them, Give me the particulars. Then I can take the brief and go and plead. I plead those facts as particulars in support that INEC, for one reason or the other, was not saying the truth when he said he had hitches. And I will now bring my own forensic experts who will now come to court and make evidence to the effect that INEC was not telling you. But all this were not done. INEC says, oh, I couldn't do it. Even that, if it were the law, INEC says, I cannot do it because I had hitches. And all the lawyers stopped there. They did not take them on it. What type of hitches did you have? Under cross-examination, this is what they should have done. And if INEC now say, yeah, I had this type of hitches, then they will have gone to call their own witnesses. As good lawyers, they will have gone to call their own witnesses. INEC says we had hitches of this nature. How do you speak to that? Then the court will now be given the opportunity to listen to the two sides. And now, as judges, look at the evidence. But all these were not available before.
Yeah, Chief Clark, let me glean some lessons from your views tonight, and this is the manner in which I'd like us to cap it tonight on two areas. One is that politically speaking, where do we go from here? Because there is a huge political tension in the land, but after this particular judgment, what's your view on where this nation is headed?
Okay, let me tell you, where we are today is that we are moving backwards in Nigeria in our law on elections. And this is what we will always get every time we hold elections, except one, the independent candidates should be allowed to contest election in Nigeria. The problem in election in Nigeria today comes from the parties. The caucus of the parties, they dictate to Nigerians whom to vote for. But because the Constitution does not allow for independent candidates, only political parties can sponsor candidates to an elective position until the law is amended to allow, because most of the problem today is caused by the political parties. They are holding Nigeria to a ransom because whoever the party decides is going to be president. You and I, we have no control over that. Therefore, if you feel our fundamental rights have not been infringed, if we have a group of lawyers who have the country at heart, let them go. Because these politicians will not change the law. Politicians control. And once you can get into the circle of the political party, then you are the king in Nigeria.
All right. So,
but unfortunately,
I mean, you touched on the other issue that I would like you to have touched on what we needed to do, but you, in terms of our electoral law. But what I'm concerned about is if you look at the votes, the margin, and how the different political parties and the candidates got their vote, Atiku Abubakar, Bola Tinubu, and Peter Obi, and how those were balkanized and long ethnic lines. That was my biggest fear. And as an elder statesman, I needed your view just in about 30 seconds so that we can wrap this up. Where do you think we can go here in healing the land? Because this country is beyond an election. This country is beyond politics. We need to come together as a people to move forward. But how do we do that?
Number one, those who can help us to move forward are the same people who are benefiting from this problem we have. For instance, look at the local government. We have no local government in Nigeria. We don't have. You know that, I know that local government chairmen are controlled by the state governors. They give them what they want to give them because their money first goes to the local government and goes to the state government. Now, let us be honest. If only our politicians will allow If ordinarily, the local government to have their right. If a man is in a close or is in whatever, and he's doing very well for his area, and he wants to be a councillor, he can never be unless he goes and joins the political party. So we have to first remove that clause in our constitution that political parties are the only people who can sponsor a candidate.
All right.
Once we remove it, then there'll be, I don't know what to, but nobody will do it because the people who are to change it are the same people who are benefiting from it, that is members of the National Assembly and the State Assembly. So my prayer is that we should jettison the whole of the 1999 Constitution. Allow you and I as citizens, from any way and manner the president can think fit, sit down, draw up a new constitution where most of the problems we have can be rectified.
Chief Robert Clark, senior advocate of Nigeria, perhaps one of the longest serving and almost 90 years, isn't it? Chief Robert Clark, thank you so much indeed for your time tonight.
I'm 85 now, going to 90.
85. Interesting. Yeah. Thank you so much for your thought tonight. We head for a break.
God bless you.
Yeah, thank you so much. We head for a break, everyone, and when we return, Chief Osita Chidoka will be joining us and talking to us about these issues and different perspectives, especially as it affects our future election. What are the lessons? Right after now, everyone. Namaste. Attention now to a former Minister of Aviation and a chieftain of the People's Democratic Party, Chief Osita Chidoka. Thank you so much indeed for your time tonight.
Thank you, Shem.
But for you, what came out to you the most in that judgment?
Well, I think the judgment is a sad day for Nigerians. Sad because I thought the judiciary would have been interested in expanding the progress we've made in election management. I do not have difficulties, I do not have issues with them finding in favor of Tinubu as being duly elected. By their own logic, they can arrive at that conclusion if they want. But I didn't like that they talked down on the petitioners. The language was quite intemperate. The language, I was the star witness in the case in 2018, and I didn't see this kind of talking down on the petitioners. I mean, it is the part of the electoral process for us to go to court instead of going to the streets. And to make it sound like the petitioners were frivolous and use such intemperate language, I was a little disturbed. Second one is that I'm ashamed as a Nigerian. Nigerians want to join BRICS. Brazil, Russia, India, China, South Africa. I'll take 3 examples. Brazil, India, and South Africa are known democracies. Brazil conducted an election, and that election was a big election, and I will figure out how many people voted in that election. So in the case of India, they had 911 million registered voters. Over 600 million people voted. 3.9 million machines were used for that election. Nobody went to court. Not one person. The Congress Party accepted the result. The world has moved on. Nobody goes to court anymore now for election. And there was a voter turnout of 67%. In the case of Brazil, there were 92,000 voting stations. There was 79% voter turnout. 79% in Brazil. And it was done with DRE machines, and there were some also paper machines involved. But in all that voting, the electronic system was subjected to public review. The political parties were present, and there was a public review. So the countries that are in the BRICS, they don't go to court after elections. The election management is such that people do not just go to court. The system is clear.
Are we gradually moving towards it?
It's a shame that our judiciary did not have strong words for INEC. Now, let me tell you, three people issued reports on this election. IRI, NDI from the US, EU from Europe, and YAGA from Nigeria. In all their reports, YAGA said INEC did not meet public expectation. IRI said, despite positive expectations, election fell short. EU said, election exposed systemic weaknesses and therefore signals a need for further legal and operational reforms to enhance transparency, inclusiveness. So instead of rambling about whether the regulations is in contradiction to the law or not, I was expecting the judiciary to be tough on INEC on that. You don't need to create these ambiguities. If you created rules for the election, then follow the rules. It shouldn't be their headache whether it was the act said so or not. But by INEC telling everybody that this is the process, and there is something that I don't know if everybody is missing. In that election, the rule was that you will snap the result to the beavers and upload to the IREV. The idea is that when you get to the manual collation center at the ward, that the person in that collation center will verify the result you brought physically with the one that was uploaded. That is why if you go to the IREV, the result from Rivers State on the IREV is different from the result announced on the INEC website. If you tabulate the result on the beavers, on some EC8As, with the one on the ward collation, then you will see the disparity. It happened in parts of Benue. Labour Party came up with that. PDP came with a strong case of failures in about almost 25,000 polling units where the rules were not followed. We listed those places and we came with an expert witness who tendered them. The court said no, that the expert witness, we should have put his witness statement on oath in the petition when we were sending in the petition. But it was when we brought the case to court that the court gave us permission to go and inspect INEC material. It was the expert investigation report of the materials, inspection of the materials, that gave right to the witness statement on oath. So there was no way you could have said something you hadn't seen. INEC needed to give us certified true copies of results for us to verify that INEC stayed by its own regulations. So there were 9,000 cases of overvoting in the election. 9,000 cases. There were almost 15,000 cases of where the INEC presiding officers did not follow the rules.
As identified by the PDP.
As identified by the PDP.
How come that the PDP find it difficult in the eye of this very trial court to prove this case with evidence?
So we came with an expert witness. But they said that the expert witness ought to have been put as part of the petition, the witness on oath. We subpoenaed him because we couldn't have done that without the man having to review the work of INEC. And we got only the power to review when the case started. So we couldn't have joined that with our petition.
One will imagine that there are copies of the results in several copies.
Yes.
The one for the agents, the INEC, and all what have you.
Yes.
And the PDP agents privy to the copies, or don't they have the copies?
Yes, we have the copies.
Yes, that is the position of the court.
Yes,
that you should have come forward with, prove your evidence with the one that you have and the one that you're disputing.
Right. The one we are disputing is the one that INEC certified. So we needed to see the INEC certified to be sure that what our agents are showing us is correct. It is upon comparing the two that we're able to make a case and say, yes, this is consistent. Doesn't it make sense? The ones our agents have are duplicate copies. So sometimes it's not very clear, but when you get the INEC certified copy, then you can see whether it was not stamped, it was not signed, it was the number of
when you deny that access.
So we got that access, and it is based on that access after the petition has started that the expert witness made his case and was subpoenaed to come and tender it. The court said, and I don't want to quarrel with the judiciary on this. I think that it is their right to interpret the law as they deem fit. But my point is the wider issue of the disgrace that Nigeria suffers. The process of going to court, it looks to me like two institutions don't want our elections to go well. The first institution is INEC. INEC is a monumental disgrace. INEC is an organization that I'm ashamed of to associate as a Nigerian. Because the promises INEC made, the promises they made with Anambra election, the Ekiti election, the Osun election. I came on this year program and called for a third-party verification of the INEC system so that we are sure that on an election day, that what is going to happen that day will not lead to a glitch. On election day, INEC said there was a glitch. When they did a mock election, they did it only in 463 or so polling units. That was small. The EU report pointed out that INEC did not test this system for a large-scale election like it did. But despite not testing the system, it's a shame that INEC goes to court to question whether not complying with its regulations is a fact, doesn't make it a ground to cancel an election. What is important in Nigeria going forward is that we have elections, like I cited. Why do we want to be amongst the BRICS if we can't conduct a simple election? India, 900 million people, and they conducted. Indonesia, 190 million registered voters, and they conduct elections.
I mean, you imagine that from your summation,
yes,
that the election of 2023, the presidential election, was a sham.
It's a joke. Okay. Because let me tell you, the votings happened at the polling unit. There were people inferred that if we had seen the results from the polling unit, and they went to collation and collated what we saw on the polling unit, I can bet you nobody will be in court. And it is possible President Tinubu will have won. It's possible.
So you don't believe in one?
So it's possible, but if you go by the allegations we made about the disparities in the election, then he didn't win.
Okay. So I'd like to ask you, do you believe in the 6.984520 million votes that Atiku Abubakar got?
If I believe or not, will mean that I need to start substantiating them.
So the question I'm asking is that Atiku Abubakar won in Osun State.
Yes.
Atiku Abubakar won in Adamawa State.
Yes.
But those fraudulently won too.
Okay, let me tell you what the problem is. The problem is not winning. I didn't think that APC will not win 30% of the votes cast or something to that effect. Well, what you see is that you go to a state like Kebbi, Atiku Abubakar comes first, and by the time the collation is finished, the difference between him and Tinubu reduces to 10,000, 15,000 votes. So the problem was not in who won a state. It is in the differential, how the results were added to cause a reduced differential in votes. So the issue is not about winning. You see, it's deceptive. Let me take the Southeast, for instance. P2B won the Southeast outrightly. And let me tell you why he did so. Because the mood in the Southeast was like the mood in the North in 2015, when the North felt it was their turn to take back power from President Jonathan. Nobody doubted that there were millions of voters turning up in the North because they were heavily mobilized, as the Igbos were heavily mobilized in viewing that this time is our turn to produce a president. So when you look at the result, that's not the problem. The problem is that in some places, there were issues. And like I said, the election of 2023 has come and gone, and it's a disaster by INEC. They delegitimize President Tinubu's win. So if he had won the election, the lack of legitimacy is because of how INEC behaved in that election. If INEC had had a problem with its servers on election day, and there was issue of non-transmission, I mean, it can happen. There was a glitch. I agree with them. What they needed to have done after the election is to scan all their hard copies and populate it in the iRev and said, the ones that were not sent on the polling unit day, we had the hard copies. This is it. Nigerians can go there and review. They could have called for a review of the election. In the case of, I think it was in Brazil, when Bolsonaro said he doubted that the results were as was done, the court refused him to even go further because there has been reviews after the election. And the court said, no, you can't challenge it. And find him for coming to the court for that. Because INEC ought to have said to everybody, look, don't worry about whether we transmitted electronically or not. After the election, see all our results. It was the same behavior that JAMB did during that Mesoma's case. JAMB just came up and said, look at the server time. At 10:20, she tested this to the result. This is what the server gave her back. She tested it again. This is what the server gave her back. They produced evidence. So nobody could fault JAMB, a public institution, fighting to retain its integrity, decided to make open his system and said, this girl was testing this thing. He tested it 4 times.
But in the case of INEC, you don't think the integrity is there?
No, the integrity is not there because they ought to have said to everybody, this is the results.
Let's look at the politics of the election. Atiku Abubakar got 6,984 votes, 520 votes. Peter Obi got 6,101,533 votes, while Bola Tinubu got 8,794,726. But you will look at it, the totality of that vote, if you put together, because there are those who believe that the reason, majorly, why if Peter Obi and Atiku had been in the same camp, maybe they would have won the election. And you look at it, if you put at the votes, the 6 million votes of over 6 million votes of Peter Obi and over 6 million votes of Atiku Abubakar, it gives you 13,086,053 votes, as against the Bola Tinubu of 8,794 votes. Atiku and Peter Obi got 11,262,978 votes in 2019.
Yes.
Don't you think it's the political issues around the election that caused this? Maybe.
So that's another story, and I would say loudly and clearly. That's why I said the court could have found that Tinubu won the election. And a review of INEC data by a third party and review could have found the same result. But I'm saying by putting this aura of infamy around the election, of misbehavior, what you have done is that they have delegitimized the election, because the point you're making is a very strong point. Nowhere do opposition parties split their votes against an incumbent government. But in this particular election, the APC was not a very popular party. And if you, like you said, if you put together the 2 votes, plus if you put Kwankwanso's votes, which are over 1 million, over a million, it would have been like 14 million. Yes. So, but the question remains that what INEC did on the election day, which is why I'm holding them responsible, will have made it that nobody will have gone to court. If they have just said, hey guys, no problem, everybody, see our results. Because like you said, this 6 million, 8 million here, that's it. See how we came about. But we know that there was a case like River State, where what was done in the polling unit was not what was reported. A case like Benue, where what was done was not what was reported. A case like the PDP brought, where there were about 25,000 polling units, where there were infractions of various types. Now, whether those infractions will substantially change the result of the election, we will not know unless we did that tabulation. And that tabulation will have been easy for INEC to have just said.
Where do we go from here?
Yes, where we go from here. I think there are 3 important issues. One is that I'm going to campaign seriously for a constitutional amendment that requires us not to swear in, to finish court cases before the swearing in of a president. I think it delegitimizes presidents when they are in office, making decisions, and they are subject of election petitions. I don't think it is good for Nigeria. I think we need to do that. And that means that we should take presidential cases straight to the highest court. In the case of Brazil, I find an interesting phenomenon. The election, they have an election court, which at the beginning of an election, the justices of the Supreme Court, Court of Appeal, and the Federal High Court elect two judges, justices from there to that court. And the president nominates 2 lawyers who are not judges to be in the panel, so that everybody sees the transparency of what was done. The kind of unanimous judgments we are getting today in Nigeria is disturbing, because under Buhari and Obasanjo, always had 2-1, 3-1, 4-2, 5-2. Reason, judges who believe in substantive justice, who don't believe in procedural, that we should use procedure to damage justice, have come out like Oguntade to say that he thinks Buhari won the election because of this substantial non-compliance. But the majority had their way. We've had somebody like the former High Ambassador to Washington who said that the 2003 election falls short of all expectations. So the nature of our justice system now makes it that I think we should have a special court for election petitions. And I think at the highest court of the land, we should determine who is president before swearing in. Second one, I think that being president with 33% of the votes in a multi-party election is a little disturbing. It doesn't give you a strong mandate. So I think we should put that 50% clause in our constitution. After the first election, the two top candidates will go out to get 50%. The reason being, it will force us at that time to vote against our ethnic divisions. We must choose of the two that we're seeing. So I think we need to put that. The third one is that I think that the Electoral Act, since the courts always rely on the Electoral Act, I think we need to annex what is in the INEC guideline into the Electoral Act. Both the EU, IRI, and YAGA talks about ambiguities in the Electoral Act. So maybe we need to be more specific about the procedure for elections in Nigeria to improve transparency. Finally, I think that it's a sad and shameful thing for Nigeria after 24 years of democracy to still be going through this type of process.
Where I would like us to anchor is about the state of your party and what is going on. I mean, there are those who also make inference that the situation in the PDP also calls for some kind of introspection. And I'd like you to listen to this. This is the FCT minister asking for this from the leadership of the party. Take a listen to him.
Let me tell you this. How would PDP have won the election when you fail to consider the mood of the nation at that time? How would they have won the election? Look at the areas that PDP didn't win. What happened? Because of arrogance, because of greed, because of impunity. If PDP had done what they're supposed to do, then you would have thought about that.
Not because of some of you who worked against
Not for some of our who feel that there should be equity, there should be justice, there should be fairness. And that's why I'm calling the National Working Committee. They should, with all matter of urgency, suspend the presidential candidate, suspend people like Abun Tabor, suspend people like Sule from the party, so they can rebuild the party.
We have 30 seconds to close. I'd like to get your comment in how the PDP can move forward from here, gleaning from what Mr. Nyesom Wike said.
Well, PDP is a party that, like you said, needs introspection. And that introspection is going on. That thinking is going on. We lost our base in the election, Southeast. We had issues with our governors, and we had challenges. I will not want to respond directly to what the FCT minister is saying, but for me as a PDP member, what he calls for is that we can remake ourselves. And that remaking of PDP means that we must look at the time of the day. The demographics of Nigeria has changed. The PDP that won elections 1999 to 2011 is not the PDP of today. The demographics of Nigeria has changed. People have forgotten our days in office. People have forgotten the great strides PDP made in moving Nigeria from a 3 billion foreign reserve country to 67 billion. People have forgotten the 7% growth in the economy that PDP did. People have forgotten that EFCC, ICPC was done by PDP. So where we are now is to remodel PDP to appeal to the demographics that has been loyal to PDP for the years.
Chief Osita Chidaka is the former Minister of Aviation and a member of the PDP. Thank you so much indeed for your time and your perspectives.
Thank you very much.
Appreciate it. But that's our show for tonight, everyone. Many thanks for watching. I'm Sean Kimale. God bless Nigeria.